Welcome to the monthly podcast presented by the Pro Bono Partnership of Atlanta. The information provided during this webcast does not constitute specific legal advice and is for informational purposes only. My name is Marguerite, and I am a legal fellow here at the Pro Bono Partnership, and today we will be talking about garnishments. Now, before speaking about garnishments, I would like to read the mission of the Pro Bono Partnership of Atlanta, which is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. For more information, visit us at our website at www.pbpatl.org. We host free monthly webinars on legal topics for nonprofits. So to begin, garnishments don't happen every day, but they can severely impact any nonprofit organization. Today I'll be focusing on three specific areas. First being general garnishment information. Second, when you as an employer are ordered to garnish an employee's wages. And third, when your nonprofit wins a lawsuit and you seek to garnish the defendant's wages. So what is a garnishment? Generally, a garnishment is a court order for property or money to be held by a third party but owed by another to be delivered to a court for a debt owed. Owned by another to be delivered to a court for a debt owed. This usually results from a plaintiff winning a lawsuit against a debtor defendant. Another term, or a term to keep in mind throughout the rest of this webcast, is garnishee. The garnishee is the third-party holder, but not owner, of property or money. So if the nonprofit is ordered to garnish an employee's wages, then the nonprofit is considered a garnishee. We'll be going over several hypotheticals involving an individual named G, a nonprofit organization, NP Incorporated, and another corporation called XYZ Incorporated to highlight the issues that we will be discussing today. So hypothetical 1, if you look on me on slide 7, NP Incorporated is a Georgia nonprofit corporation. One of its employees, G, recently defaulted on a $10,000 loan from Fulton Bank, who then filed a suit against G in Fulton County Magistrate Court. Fulton Bank wins the suit, but G still refuses to pay. Fulton Bank now seeks to garnish G's wages and asks the court to order NP Incorporated to deliver some of G's earned but undistributed wages to the court. NP Incorporated in this situation is the garnishee. Now, there are two forms of garnishments. The first is called a regular garnishment, which is where the garnishee delivers the ordered property or money to the court a single time. After that single time, the garnishee's duty is now over. The other form of garnishment is called a continuing garnishment. This is where the garnishee delivers their employees' wages to the court multiple times over a period of time, usually around 180 days. An example of this is an employer sends in a portion of its employees' wages every 45 days for 180 days. This webcast will focus on continuing garnishments, that is, garnishments of a person's wages. Now, if you look with me on slide 9, while you do not need an attorney to file the basic papers such as the answer, you are required to have an attorney if you are required to respond to a dispute to the answer, which we'll get to later in the webcast. Now, the next several slides will deal with solely where the nonprofit is playing the role of the garnishee. So let's look at slide 11. So for the garnishee, or the nonprofit, the garnishment process generally begins when they receive a document called a summons of garnishment. The summons of garnishment has several pieces of information, such as whether it's a regular garnishment or a continuing garnishment, the identities and the addresses of the plaintiff and the defendant, the property or money which is owed to the plaintiff, and if money, how much, which court ordered the garnishment, and lastly, deadline information on when to file the answer. So once an employer receives a summons of garnishment form, it is required to file a document called an answer within a specified period of time. So how do you file that answer? If you look on slide 13, there are several considerations to look at. First, the nonprofit needs to look at whether if it is a regular or continuing garnishment. And on the summons of garnishment, it'll say at the top. Next, the nonprofit employer must calculate the employee's pay and how much to garnish from that employee's income. We will go over that process in the next several slides. Next, after calculating how much to garnish, the nonprofit employer must submit the money and property with the filled out answer sheet. You can call the clerk of the court that ordered the garnishment for general questions and to determine what forms of payment are accepted and how to turn in the money or property correctly. Last, the answers must be filed no later than the deadline set by the summons of garnishment form. And usually in most counties in Georgia, it'll be not sooner than 30 days, but not later than 45 days. Do not miss this deadline, for the penalties are very severe. Now for continuing garnishments, garnishees must file additional answer forms just like the procedure I explained in slide 13 with the money owed every set period. So for example, in Fulton County, continuing garnishments require the nonprofit employer to refile and submit money owed every 45 days for a 195-day period. So how much can you garnish? If you look at slide 15, these are the rules set out by Georgia. So there are restrictions on how much you can garnish an employee's wages. And they are basically broken down into two steps. The first is no more than 25% of the defendant's employee's disposable income per week, so after tax income, or the amount by which disposable earnings for that week exceed 30 times the federal minimum hourly wage prescribed, which comes out to approximately $217.50 a week, whichever is less. Now, this verbiage is a little confusing, so if you look on slide 16, I've broken it down for you. So if the employee's weekly after-tax earnings are less than $217.50 a week, no garnishments is possible at all. If the weekly earnings are between $217.50 a week and $290 a week, then you may garnish all amounts above $217.50. Lastly, if the weekly earnings are greater than or equal to $290 a week, then you may garnish 25% of the disposable weekly earnings. Now there's a small exception if the garnishment is for alimony and child support. In these situations, Georgia law allows up to 50% of the disposable income being garnished instead of 25. So please keep that in mind. So let's look at another hypothetical on slide 17. So back at NP Incorporated, you look over G's recent wages. You find that G earns $500 a week after taxes. Because G earns more than $290 a week, Fulton Bank can garnish 25% of the $500, which comes out to $125 a week. If G on the other side of the coin, if G earned $217.49 a week after taxes, Fulton Bank cannot garnish any of G's wages. Now, after filing the answer along with the money owed on time to the court, you are required to mail a copy of the answer to both the plaintiff and the defendant employee. Ask the clerk of the court or the deputy clerk when you file the answer how to file what is called a certificate of service, which acts as proof that you mailed a copy of the answer to both the plaintiffs and defendants parties. And generally, in some counties, the answer form will have a space at the bottom, which acts as the certificate of service. Now, previously, I said to make sure to file the garnishment or the answer to the garnishment summons on time. That's because the penalty is very severe. If the garnishee does not properly file an answer on time, then the plaintiff may receive what is called a judgment by default or default judgment against the garnishee, which is the nonprofit employer. In this case, the garnishee will owe the entire amount that the defendant owes the plaintiff. So an example of this is if a nonprofit employer fails to file the answer on time, then the plaintiff may be allowed to garnish all the money that the plaintiff is owed from the nonprofit's own bank accounts instead of the garnishments of G's wages. So regardless of nonprofit, this could be a serious penalty that could seriously harm the mission of the nonprofit. So that concludes the slides for where the nonprofit acts as the garnishee. The following slides will deal with issues when the nonprofit is the plaintiff and seeks to garnish someone else's wages. Now, a reminder, continuing garnishments are only possible when you're garnishing wages. So first and foremost, to begin, if a nonprofit seeks to garnish someone's wages, the nonprofit must win a lawsuit against that particular defendant. So there must be a separate lawsuit and a separate case to be concluded first. Then, in order to garnish someone's wages, you will need to determine if that particular defendant is employed, and if so, who is their employer. So let's look at hypothetical 3 on slide 22. You are the executive director of NP Incorporated. You would like to apply for 5 new available grants and hire G to apply for them. After paying him for his services, you find out that G did not work on a single grant application. You bring a lawsuit in Fulton County Magistrate Court. G fails to answer the complaint, and the judge awards NP with damages. Even after the lawsuit is over, though, G refuses to pay. NP now has an option to garnish G's wages. Or NP now has an option to garnish G's wages, So how does a nonprofit plaintiff begin the garnishment process? First, the nonprofit employer or the nonprofit should obtain a certified copy of the original judgment from the clerk of the court where you won your lawsuit. So go to the court where you won your lawsuit and ask the clerk for a certified copy of the judgment. Second, the defendant and the garnishee, which in this case is the defendant's employer, they both need to be notified about the garnishment, so you need to find the addresses of both of the defendant and the garnishee. Next, you need to determine which county to file in. So Georgia law states that you must file garnishment papers with the county court where the garnishee employer is located, not the defendant, but the county where the employer is located. Next, you determine which court in that county to file. If the amount in controversy is valued up to $15,000, then file in magistrate court. Anything over that, file in state court of that county. Now, not all counties have state courts. So if that is the case, then file in magistrate court. Next, call the clerk's office of that court to determine filing fees, for they vary greatly from county to county. Now, as I said in slide 23, you're responsible for finding the identities and the addresses of the defendant and the garnishee. Since you won a lawsuit against the defendant in a previous case, you probably already know the addresses and the identity of the defendant. So you need to find the identity and the address of the garnishee employer. So if you look with me on slide 24. So the rules are: if the garnishee is an individual, file in the county where this person resides. But if the garnishee is a company in Georgia, then the process is a little more complicated. But if you look with me, on slide 24, there's a web address, sos.ga.gov/corporations. Click on that link, and on the right-hand side, there's a blue button called Corporation Search. Then you click on that link, and it'll take you to a search page. On that search page, fill in the name of the garnishee's name. And after clicking search, it'll bring up the search results, and you will be able to find the name of the garnishee employer, and it will provide information of such as the identities of the officers in the corporation, but most importantly, the main mailing address of that corporation. Please use this address to serve the garnishment papers to the garnishee. So after you found out all this information, fill out and file a document called the garnishment affidavit with the clerk or deputy clerk of that court. Sign the affidavit in front of the clerk. That is very important. And each court's website will have copies of all of these forms. So additionally, when you file the garnishment affidavit, make sure you file the certified copy of the original judgment with the garnishment affidavit. So let's look at hypothetical 4 on slide 25. So as the executive director of NP Incorporated, you find out that G works for XYZ Incorporated in Sandy Springs, which is located in Fulton County. Taking a certified copy of your original judgment, go to Fulton County Magistrate Court. And because damages here, hypothetically speaking, are less than $15,000, or you file in magistrate court because in this hypothetical, damages are less than $15,000, and file the garnishment affidavit with the clerk or deputy clerk of Fulton County Magistrate Court. Now, after you file the affidavit, if everything is in order and there are no errors, then the clerk will issue the summons of garnishment. Now, before you file the affidavit, ask the clerk ahead of time if a summons of garnishment form will be provided or if you are to bring a blank form to them. Now, a small little change for continuing garnishments. When you file the garnishment affidavit, you must bring 7 copies of the garnishee answer form and deliver it to the clerk's office. And that's because the garnishee is going to have to file multiple answers over a certain period of time. And like I said, all of these forms will be available at that particular court's website. Now, after the clerk of the court produces a summons of garnishment, both the garnishee and the defendant need to be notified. If you look at me at slide 17, the way you do that is you must send a summons of garnishment to both of these parties. Slide 27. Excuse me. Sorry. Now for the service on the garnishee, there is no wiggle room with it. You must pay the county sheriff a set fee to deliver the summons to the garnishee, and that is set by law. And every county there's different. The fee is different on paying the sheriff. Now, service on the defendant, there's several options that the nonprofit can take, and they vary based on cost and effectiveness. One option would be direct service by the sheriff. So just like having to pay to serve the garnishee, the nonprofit can pay the sheriff to serve the defendant as well. And these fees vary from county to county. For example, in Gwinnett County, the fee is $50. Another option is to use companies called process servers. These are private companies that will properly and effectively serve the defendant. This is the most effective option, but it's also the most expensive. Lastly, you can personally mail out a copy of the summons of garnishment no later than 3 business days after the service of summons on the garnishee. Now you can do U.S. Postal Service registered or certified mail with return receipt requested, or FedEx or UPS overnight delivery with signature. Now, this is the least effective because defendants may refuse to sign the return receipt. If you are doing mail service, file the return receipt with a court. If the particular court has a requirement of filing a certificate of service form, attach the return receipt with the certificate of service form as well. Now, for continuing garnishments, because the period is only approximately 180 days, or in some counties 195 days, if the defendant still owes you money after the final payment is received, you will need to refile another garnishment affidavit and begin the whole process over again. And this includes having to repay all the fees every pay period. Now, each court has its own deadlines to file the garnishment, for the garnishee to file an answer. If you look at me on slide 29, but most courts give you a deadline of no sooner than 30 days, but no later than 45 days to file. If the garnishee does not file the answer within 60 days, you as the plaintiff are allowed to take a default judgment and garnish directly from the garnishee employer. So in one of the previous hypotheticals where I explained where if you don't file the answer on time, the plaintiff may file from your own personal bank accounts. In this situation, as where you are the plaintiff, if the garnishee does not file an answer within 60 days, then you are able to do that as well. Since in this case you are the plaintiff. You're playing the role as the plaintiff, excuse me. That is the end of our garnishment webcast. I hope this information was helpful. If you would like more information about the services that Pro Bono Partnership provides, please contact us at 404-407-5088, or you can email us at info